Mr. Muller's case is 25M1510. Mr. Muller, good morning. Mr. Guard, good morning to you. Case comes on for continued arraignment. I think there's a pending motion.
Yes,
I remember. Let me start. I think I've read the defense position based on the motion. Okay. Let me just hear from Mr. Muller then. Mr. Muller, you understand the motion Mr. Guard filed?
Yes, sir.
What's your position on the motion?
There was another law firm that had called me telling me they wanted to take the case.
Okay.
They told me that I had to fire him before I hired them on.
Okay.
Then when I called them back and I had let them know that I had let him go, that they wanted $6,000 from me.
Yeah.
So now I don't have representation. So.
Well, you currently have representation. Mr. Guard is currently your attorney.
Uh-huh.
There was a motion filed asking to withdraw to remove him from the case.
Uh-huh.
I haven't granted that motion yet.
Yeah.
I wanted to talk to everybody before we take that step.
Yeah.
So what is it that you want to do as far as representation goes? What do you want to do? You can just talk to me. Just tell me what you're thinking.
Well, honestly, I wanted to ask for recusal today or demand recusal on violations of oaths of office. But
So hold on, recusal, have me recused?
yes, sir.
Okay, well, let's talk about your representation first.
Okay. Yeah, I wanted a lawyer.
Okay.
That's moving forward. I wanted a lawyer, but
Okay.
now I want to represent myself, sir.
Okay, I want to make sure I followed that. You had wanted a lawyer,
Yes.
applied for the public defender,
Yes,
you got
sir.
alternative defense counsel,
Now I'll just represent myself, sir.
looked into private counsel, probably going to be too expensive, likely.
Yes, sir. Yeah.
And you want to go forward and represent yourself.
Yes, sir.
You can do that. Of course, you know that. You have the right to do that.
Yes, sir.
And we're not set for a trial or anything yet. Are you hoping to set for trial as well today?
Yes, sir.
Okay. We're going to have to talk a little bit about that then. Before I do that, though, let me just check. Mr. Guard, I've read the motion. Any other record do you want to make? Mr. Mueller does not want to be represented by an attorney. All right. I'm going to release you. I'll grant the motion to withdraw based on Mr. Mueller's request. You are no longer his attorney. You're free to go. Or if you have another case, stick around. So, Mr. Mueller, now you, like you said before, predicted, you now are representing yourself, no attorney.
Awesome.
Okay.
Thank you.
Now, what do you want to do with your case? I heard you say set for trial.
Yes, sir. I mean, I would like to just throw it out, to be honest. I mean, this should have been thrown out at Deacon's closet. It's a violation of a lot of rights, sir.
Can I just pause you on that?
Yeah.
I apologize. And I know you have some issues, legal issues you want to bring up. This is not the right moment to do that.
Yes, sir.
So that's why you want to go this direction. I want to just deal with the one issue right now, which is, do you want to set the case for trial today, or do you want some time to negotiate yourself with the district attorney? Or
Well, I haven't consented to any of this, sir. Everything I've done up to this point has been under duress and coercion.
so let me try it again a different way. Do you want to set for trial, or do you not want to set for trial?
I would not like to set for trial.
Okay.
I mean, I don't consent to any of this. So
What you're about to watch is a perfect example of what happens when confidence massively outweighs competence. This case isn't just about a courtroom appearance. It's about a defendant who believes reading a few books and absorbing internet talking points somehow makes him immune to the legal system. From the very beginning, this hearing spirals into a clash between a calm, methodical judge and a self-proclaimed healer who thinks consent, duress, and personal philosophy can override criminal procedure. And here's the twist. The court actually bends over backwards to protect this man's rights. The judge explains things clearly, gives warnings repeatedly, and even safeguards his speedy trial rights without him asking. But instead of recognizing that, the defendant doubles down, rejects professional help, and insists on steering the ship himself, straight toward the rocks. As this case unfolds, pay close attention to how patience slowly turns into legal inevitability. Because while the defendant thinks he's reclaiming control, what he's really doing is stripping away every safety net he had. And by the end of this video, you're going to see just how expensive being heard can become when the law is listening very carefully.
What I'm going to do today then is I'm going to enter a not guilty plea on your behalf.
Well, I haven't entered a plea, sir.
I know, I'm doing it on your behalf.
10-4. Or you don't use 10-4 here, sorry.
I understand it.
Yeah.
Speedy trial starts today. And that's preserving your right to a speedy trial. I'm now compelling, on your behalf, it's what your attorney would have done for you, compelling the prosecution to resolve this case within 6 months of today. That's preserving your right to a speedy trial. That deadline will be April 27, 2026. We're not setting it for trial yet. You're not asking for a trial date, but we're now pushing the DA. Say, you got to take care of things. And if they don't resolve the case at a trial or through a plea bargain, case will be dismissed.
Yes, sir.
Okay? So we'll set it for a pretrial conference. How much time do you think is useful for you to figure out how you want to proceed with the case?
Well, I think me and the DA are going to have a conversation
Great.
after this. So thank you.
Okay.
Yeah, we'll figure it out, and whatever date you deem.
Sure. So we can do 4 weeks from now. That gives you just under a month. Is that too much time or not enough?
I mean, I have to be here for another case anyway. I'm a witness in another case, so
Okay.
That's the 9th of December. So I'm good. I got to be here till the 9th of December anyway. So
I'll be in town, you mean?
I have to be in town for
Okay.
for that.
So let's do the 24th then of November.
Okay.
Let's do November 24. We'll set that at 9 a.m. It's an in-person appearance right here in Division 7. Between now and then, if you want to talk directly with the DA, make sure you have their contact information, email, phone number.
Got it right here.
Yep. And I know I've talked to you about this, but I just want to make sure, you don't have to talk to them. You don't have to.
I would rather reach an agreement, sir. It's gone on for way too long. I'd rather gracefully step out of the arena than I want to get back to the garden. I'm a healer, and like I've been doing a lot of work in this town for the last 2 years, off and on. So I don't want to be in spaces that harden my heart. So
I got you.
I just want this to be done with and
Okay.
move forward with my life and heal myself and allow others to heal.
And I appreciate that
Yeah.
spiritual position.
Yeah.
I'm speaking from a slightly different legal
I understand.
position. And I think you know this. I just want to say it out loud.
I can't like negate who I am. So
I got you. I'm not asking you to.
yeah.
That's the prosecutor. They're not your attorney. You don't have to admit any facts or say, I was there at Deacon's Closet or this happened, but this didn't happen. You don't have to do any of that because what you say can and will be used against you. That's the prosecutor.
Well, yeah, I already heard the plea deal from my previous attorney. So I mean, as long as we can reach an agreement, as long as we can reach an agreement, that's fine. So,
Okay.
Yeah.
If you can't reach an
not,
agreement,
yeah.
we'll talk about it in November. We'll talk just like this.
Cool.
Again, there's no surprises.
Yes, sir.
I'm going to talk to you however I need, to get the information to you. So if we don't reach an agreement, it's okay. There's other steps and we'll
Appreciate your
talk
plan.
about them. Okay.
Thank you.
All right. Anything else, Mr. Mueller?
That's it.
All right. Thank you, sir. I appreciate it. Have a good day.
This is the first major red flag moment, and it's one seasoned courtroom watchers recognize instantly. When a defendant fires their attorney without a solid replacement plan, it's rarely about strategy. It's about emotion, ego, or mistrust. The judge is doing exactly what the law requires here. Slowing things down, making sure this choice is voluntary, informed, and not driven by confusion. What's important is that self-representation isn't some power move. It's a legal right, yes, but also one of the riskiest decisions a defendant can make. Lawyers exist to protect people from procedural landmines they don't even know exist. By choosing to go pro se, Mr. Mueller isn't gaining control. He's assuming responsibility for rules, deadlines, objections, motions, and consequences he clearly doesn't understand yet.
Mr. Mueller's case 25M1510. Mr. Mueller's case comes on for a pretrial conference. Mr. Mueller here, pro se, without an attorney. Mr. Mueller, good morning, sir. Let me check in with the DA first. I'll come to you second. Okay. DA?
Yes, Your Honor. I conveyed the offer, and he informed me that he would like to go to trial as a pro se individual.
Mr. Mueller, is all that correct?
Yes, sir.
I have a speedy trial date of April 27, 2026. Does that check with both parties?
Yes, Your Honor.
I'd like to get out of town sooner than that. Is there any
Oh,
way
no,
that-
that's not the trial date. I'm sorry, sir. That's the speedy trial deadline date.
Oh, okay.
6 months from the date we entered the not guilty plea
Okay.
last time. That's just the deadline by which this case has to be resolved.
Okay. Thank you.
I'm just making sure I
Gotcha.
wrote it down right. Everybody agree?
That's
Yes.
Okay. No, we're going to get the trial way sooner than that.
Okay.
That's way too far out. All right. And I don't know if you put it, no, I don't see it on my notes last time. Would you put the offer on the record,
Yes, Your
please?
Honor. The offer is to plead guilty to petty offense trespass and close with conviction.
Mr. Mealy, you understand that offer in the case?
Yes, sir.
Okay. And you understand this. I have to advise you of this. So I don't mean this to sound like anything other than me making sure you understand the decision you're making.
I'll let you talk.
Thank you. I've had people who took this the wrong way.
Yeah.
And I have to advise you. I have to make sure you understand if you go to trial,
Mhm.
as you're asking, and if you are convicted, I'm not saying you would be, but if you were
Mhm.
convicted of the top count, class 2 misdemeanor, obstructing a peace officer, the worst case punishment you could face, and I'm not saying you would face this,
Yeah.
but the worst case you would face is up to 120 days in jail
Yes, sir.
on that conviction.
We've already talked about that. Yeah.
Yep. Versus the plea offer here, which would be a petty offense conviction and no additional sanction. You understand the difference between those two things?
Yes, sir. I'd just like to be heard. Yeah.
I got you.
Yeah.
No, I got you. That's fine. The only reason I had to do that is because there's been appellate cases where somebody's gone to trial, they were convicted, and then at the end, after the conviction, said, "Well, I didn't know
Yeah.
what I was facing. I didn't know that I was exposed to this worse sentence, and I would have taken the petty offense plea."
Yeah.
You're not in that camp. I know that.
Yeah. I would prefer to be heard over the 3 months. I'm well more than willing to take the 3 months just in order to be heard, sir.
What do you mean through? Oh, 3.
Yeah.
Oh,
yeah.
I'm sorry.
I'm willing to put that on the line is what I'm
The
saying.
penalty.
Yeah.
3 months would be 90 days. 120 days is 4 months of
That's
potential incarceration.
Still okay.
And again, I'm not saying you would face that. It's just the worst case.
Yes, sir. Thank you.
I got you.
Here's where ideology starts colliding with reality. The phrase, "just throw it out," sounds powerful to someone unfamiliar with court procedure, but it has zero legal meaning without a valid motion, legal grounds, and proper timing. Courts don't operate on vibes, personal beliefs, or claims of spiritual authority. They operate on statutes, precedent, and procedure. When he starts talking about violations, coercion, and consent, what he's really doing is borrowing sovereign citizen-style language without understanding how courts actually evaluate those claims. The judge immediately shuts this down, not to silence him, but because this simply isn't the stage for it. This is a recurring pattern in these cases. Defendants want the courtroom to function like a debate club or philosophical forum. But criminal court is transactional. You're either moving toward trial, negotiation, or dismissal, and none of that happens through abstract declarations.
So let's get some dates then with that April deadline, much sooner than that. When are you thinking of getting out of town, Mr. Mueller? You mean moving or just traveling?
I'm just traveling,
Okay.
so I'm a nomadic, so
How soon would you like the trial?
as soon as possible, really.
Okay. Do you want a motions hearing, a constitutional motions hearing, or anything like that?
I don't know the difference between that, so constitutional. Sorry, repeat that.
Yeah, sure. Do you have any motions you wanted to file in the case?
No.
Okay. You just prefer go right to trial?
Yeah.
Okay.
Yeah.
I'm asking because if you wanted a motions hearing, I'd set a motions hearing, then a month later set a trial. If you want to do the trial, we'll try to get it as quickly as we can.
Just as quickly as we can. Yeah.
Okay. Yes, and you'd like a trial to a jury,
Yes,
not for
yes.
the court.
Yes. Yeah.
Jury trial. You got
Yeah.
it.
Thank you.
Can the people do the 16th of December? I got to tell you this. I've set quick trials. I've never set one this quick.
Cool. Yeah. Let's go. Yeah.
So the only issue with this is a couple issues. One, DA, you obviously have some police officers that you need to subpoena. So they say they're available, but they have to check with the witnesses I suspect that they'll have and make sure those witnesses are available, especially over that kind of holiday period of time.
Yeah.
If possible, they might tell me by the end of the week, Judge, that date actually doesn't work. We need a different date.
Okay.
So that's possible. So I don't want you to lock that in.
Okay.
In pen, put it in pencil. The
Yeah.
second issue that we have is I want to make sure that you're good with that date, that you have everything you need to be ready for trial. And it's just a few weeks out.
Yes, sir.
We'll talk about that just a little separately.
Okay.
But for right now, you're good with the December 16 and or 17, because I set it over a 2-day period of time. Tuesday, Wednesday. Good for you?
Yeah, that's fine, sir.
Okay, here are the dates and times. You might want to write these down. You got a pen?
I'll just write it down on my phone.
Okay. So the trial will be December 16 and or 17. That's Tuesday, Wednesday. For right now, plan on 8 a.m. in person right here. Got it?
Thank you, sir.
Continuing, I'm going to set what's called a court's disposition deadline. That's a cutoff deadline. And I know you don't want to enter into a plea bargain, but I find it's useful just to have a deadline anyway.
Okay.
If you want to think about this, or if you wake up one day and you say, I think I'd rather just
Take the charge and
take
get out
the
of here.
petty and get out of here. Exactly.
Yeah.
I'll give you until December 8th. That's a little over a week before the trial.
Thank you.
December 8th.
Thank you.
That'd be the cutoff. You don't have to show up. You don't have to show up in court by that deadline. But
Understood.
if you want to make some plea bargain or you negotiate something better,
Okay.
all you have to do is either let me, the court, know directly, or let the DA know directly, and they'll file something and let me know, and we can vacate the trial so we don't bring jurors in.
Gotcha.
And we can resolve it on a different day. But I just want that decision must be made by the 8th, and I have to hear about it by that deadline.
Okay. Thank you.
Sure. Continuing. There's what's called a Rule 16 deadline. I'll set that for December 1, 1st of December. That's a week from today. And you have obligations on this day. The DA does too. December 1, both parties must file with the court any witnesses you have that you intend to call, expected witnesses, including any expert witnesses. I don't suspect either side will have experts in the case. Let me just ask, DA, do you expect any experts in the case?
Give me 1 minute, Your Honor.
Sure. It's an alleged trespass obstructing.
Assuming no, but let me double check.
Okay.
No, Your Honor.
Okay. Mr. Muley, do you expect to endorse an expert or bring in an expert witness to talk about something?
Not that I know, but now that you've mentioned it, I probably should.
Maybe.
I'm gonna look into it now.
This moment is critical, and most viewers won't realize how much protection the judge is actually providing here. When the court enters a not guilty plea on the defendant's behalf, that isn't a power grab, it's a safeguard. Without it, Mr. Mueller could unintentionally waive rights he doesn't even realize he has. By entering this plea, the judge triggers the speedy trial clock, forces the prosecution to act, and creates a hard deadline for resolution. This is exactly what a competent defense attorney would do. The irony is thick. While the defendant insists everything is under duress, the court is actively preserving his rights despite his resistance. This is what judicial professionalism looks like, protecting someone from themselves while staying firmly within the law.
Yeah.
But the deadline to do
16.
the deadline to do that will be the 1st. No, the
Oh.
trial is the 16th.
Yeah. Okay.
First, you have
I'm
one.
sorry. I heard the rule of 16 and my
That's,
brain.
that's Rule 16. That's the rule number.
Gotcha.
It's a standard deadline.
Yeah.
I'm setting that on December 1st. So 1 week from today, you must tell me,
If
file
I'm
with the
bringing
court.
any experts.
Not only that, but any witnesses you have. So
Okay.
any regular witnesses. I got a buddy who was there, who saw
Yeah.
everything happen.
Yeah.
If he or she's going to be here testifying, you must endorse that person, meaning write their name down, their contact information, and file that with the court. Experts are people who are not necessarily witnesses that saw something or heard something, but they could illuminate some more complicated topic
Yeah.
or subject for the jury.
Civil rights. Yeah.
I wouldn't have a civil rights. It's not people to eliminate the rule of law. That's a different thing. That would be me. It would be a more of a factual thing. And that's why I said to the DA, I don't know that there's any factual issues that require an expert in the case. But if you could think of one,
Okay.
you're welcome to file one. I can tell you for sure there will not be any experts who educate the jury on areas of law.
Yeah.
That's not an appropriate use of an expert witness.
Hmm.
Okay.
Okay.
But
Question.
Yeah.
Sorry. Then this may be.
it's okay.
But am I allowed to explain law to a jury?
No, what you can do is, well, a couple things. One, I will give the jury the rules of law that apply to this case. I will do that. I'll do that in writing. You have the ability to weigh in on what you believe the rules of law that they should be instructed on are. You get to help or at least provide input as to what the rules of law you think need to be highlighted to the jury are. And I'm going to get to that. I haven't even talked about that
Okay.
yet.
All right. I'll let you get
the-
through it.
I will instruct them on what the law is. Secondly, though, you may comment on
Thank you.
those rules of law for sure during your closing arguments in
Okay.
the case,
Okay.
for sure.
Okay. That makes sense.
All right. So that's the Rule 16 deadline. Witnesses provided to the court. Any expert witnesses, provide them to the court. Additionally, you have another obligation that's you must provide by next Monday, the 1st, what's called your defense, the nature of your defense, the nature of your defense. Now, listen carefully. That's not That's not what the whole story of your defense or why you think you're not guilty factually. It's just legally, what's the nature of your defense? For example, Judge, I'm not guilty because I wasn't me. They got the wrong ID, wrong person. Or, Judge, I'm not guilty because the DA can't prove the elements of this charge beyond a reasonable doubt. So maybe I was there, maybe I wasn't, but the DA can't prove the charge. That's what's called a general denial, not a specific denial. Or I'm not guilty, maybe not, doesn't apply in this case, but maybe I'm not guilty because self-defense. Yes, I did this. I hit somebody, but I did it defending myself, which means you're not guilty.
Yes, sir.
That when I say nature of defense, I mean just a phrase like that. General denial, self-defense.
That's also December 1st.
December 1st. You have 1 week to provide that to the court. That's
Can I just do that with the clerk's
Yep,
office?
you can file it right with the clerk's office. Yep. That's the Rule 16 deadline is next Monday for those witnesses, experts, and nature of defense.
Thank you.
Got it?
Appreciate you.
This is where personal identity starts clashing dangerously with legal reality. There's nothing wrong with spiritual beliefs, personal philosophy, or seeing oneself as a healer, but none of that carries legal weight in a criminal proceeding. And to the judge's credit, he acknowledges the sentiment without validating the legal relevance of it. Courts deal in evidence, conduct, and statutes, not intent, self-concept, or moral self-assessment. The moment someone starts framing their defense around who they are instead of what happened, they lose footing fast. What's even more telling is how gently the judge warns him about speaking to the prosecutor. That's not condescension, that's damage control. Because statements made in moments like this don't heal cases. They become evidence.
Sure. Now there's another thing we need to talk about. I'm going to issue, can you actually do it in writing? Print it out? Correct. Oh, you've already got
On top of it.
read my mind. Most people get that electronically. I want you to get a physical copy so that you don't have to wait for it in the mail or something like that.
Okay.
So that's what's called a case management order or my trial management order.
Okay.
It lays out a lot of rules about just procedures on how to get through trials efficiently. And it's not just for you, it's for even attorneys as well.
Yeah.
There's a couple things I want to highlight in there. You'll read it, but I want to highlight it for you as well.
Okay. We can go over.
The Wednesday before trial. The Wednesday before trial. And that Wednesday is December 10. You must provide, and the DA as well, you must provide 3 things directly to the court. 1, what we call motions in limine. Motions in limine. A motion in limine is a motion regarding an evidentiary issue or some other issue that will affect how the trial goes. Not a constitutional motion or a motion to dismiss or something like that. It's just if you have a question or a concern about, say, evidence in the trial, Judge, the DA has body camera evidence, and I think there are clips on the body camera that shouldn't come in for one reason or another.
Mhm.
That's a good topic for a motion in limine, meaning we could talk about it before the trial, so we're not arguing about how to edit a video during the middle of a trial,
Okay.
something like that.
Okay.
If you have issues like that, or the DA, they must file that motion in limine by Wednesday before trial, noon, it says on there, so that I can review that and prepare a ruling on that so we're ready to go for trial.
Okay.
So 3 things, motions in limine. The second thing is an updated witness list. So on Monday, if you remember the 1st, you're going to give me all the witnesses you have.
Mhm.
Then the Wednesday before trial, you will tell me exactly the witnesses you are more likely intending to call. Sometimes people might say, I have these 5 witnesses, but then as you get closer to trial, you're like, you know what? I think I only need 3 of these witnesses. The DA does this all the time. They say, we have 5 witnesses, Judge. We figured out 2 of the police officers don't need to testify. We're just going to use 3 witnesses.
Mhm.
That's what you need to tell me Wednesday before trial. Who are you really going to call? Because I just need to manage the timing of the